national government can do those 27 powers expressly stated in Article 1, Section 8, and it can also do an unspecified quantity of things for the necessary and proper clause. So, what are the powers of the federal government? Well, now they're 27 plus X. We get worried about X's, don't we, and unknown quantities. Although something of an overstatement, we can say that for the strict constructionist, the national government can do only those things which the federal government expressly says it can do. For the loose constructionist, the federal government can do what it wants, except where the Constitution says it cannot. I trust you realize these are two very different views of limited government, because the Tea Party movement adopts the original Jeffersonian view. Restricted to express powers. There are certain things that we can do. There are about 27 things that we can do, and that's it. And for Hamilton and Washington, and later John Marshall on the Supreme Court, you can do those 27 things, plus lots of other things. Hamilton says as much in the Federalist Papers. In Federalist 78, Hamilton writes, by a limited constitution, goes back to the question how Skousen and others don't tell us, well, what do we mean by limited government? Well, Hamilton tells us very clearly in Federalist 78 what he means by limited government. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. Such, for instance, as it shall pass no bills of attainder, no post facto laws, and the like. And those are things that are detailed in Article 1, Section 9 of the Constitution, prohibited to the federal government. It should be clear, these two rival theories of constitutional interpretation embody significantly different understandings of the nature of limited government. These different understandings of limited government are so different that from the viewpoint of the strict constructionist, loose construction was not limited government at all. The fear of the strict constructionist, and currently the Tea Party movement, was that once a government allows for implied powers, where do implied powers begin, and more importantly, where do they end? This debate over the extent of the constitutional powers of the national government was not a mere legal debate with no political overtones. As I've already noted, those who were in the anti-federalist camp over the ratification of the Constitution would become strict constructionists. It would be argued that they were attempting, through questions of constitutional interpretation, to make the Constitution more like a traditional confederal Constitution. Most of those who were Federalists, such as Hamilton, Washington, James Wilson, would be loose constructionists. The major exceptions to that last statement are Jefferson and Madison. Jefferson, however, was at best a lukewarm Federalist. And while Madison moved from being the father of the Constitution and such a strong supporter of a national government to the strict construction position is an intriguing question that is beyond the scope of our present concerns, but likely has much to do with the long-time friendship and political association that Madison had with Jefferson. It should be clear when we consider both the debate over the General Welfare Clause and the debate over the Necessary and Proper Clause that Hamilton's Constitution and national government are quite different from Jefferson's Constitution and national government. What are the powers of the national government? We get dramatically different answers from Hamilton and Jefferson. Washington was convinced by Hamilton's opinion on the constitutionality of the bank. So the bill to create a Bank of the United States was reintroduced in Congress and narrowly passed. The debate over the Necessary and Proper Clause would lie dormant over the next 15 years or so. Jefferson's Republican Party even seemed to assume something of an acceptance of the bank. A second Bank of the United States was chartered when Madison was president, and the Jeffersonian Republicans, now known as Democrat Republicans, controlled Congress. This second Bank of the United States would lead to one of the most important decisions in the history of the United States Supreme Court.